Can I get shared custody of my son if I was not named as the father on his birth certificate? The short answer: yes. But only with the mother's permission can an application be made to the High Court. The whole question. My girlfriend and I weren't together when she fell pregnant, but we were always on good terms. Her family came to mine and insisted that we don't pay damages, so we agreed. After the baby was born, I was not listed as the father on his birth certificate, but I'm worried that if something went wrong down the line, I wouldn't have access to him. Can I change his surname to mine and gain parental rights? The long answer. Let's start with the changing of your son's surname to yours. The law under which a surname can be changed is the Births and Deaths Registration Act of 1992. The Home Affairs website says that this provides for the rectification, amplification, and amendment of the personal information of individuals as contained in the National Population Register of South Africa, NPR. But as your son's mother is taking parental responsibility for your son, you would need her consent to change your son's surname to yours. To go on to the custody question, the new Children's Act that came into force in 2010 provides for automatic parental responsibilities and rights for unmarried fathers who meet certain criteria. There are two different ways in which a biological unmarried father can acquire full automatic responsibilities and rights, she says. Firstly, he must be living with the mother in a permanent life partnership at the time of the child's birth, Section 21(1)(a). Alternatively, an unmarried father not living in a permanent life partnership with the mother must satisfy the following criteria. 1. He consents to be identified as the father or pays damages in terms of customary law, and 2. He contributes to, or has attempted to contribute to, the child's upbringing for a reasonable period, and he contributes to maintenance and expenses of the child for a reasonable period, Section 21(b)(e). Matthias says that an unmarried father who does not satisfy the criteria above for automatic acquisition of parental responsibilities and rights can acquire either full or specific parental responsibilities and rights through agreement with the mother. The parental responsibilities and rights agreement must be in the prescribed format, and it will only take effect once it is registered with the family advocate or is made an order of the High Court or Children's Court. An application for guardianship, Section 24 of the Act, can only be made to the High Court. The High Court must take into account a. the best interests of the child, b. the relationship between the applicant and the child, and any other relevant person and the child, c. the degree of commitment that the applicant has shown towards the child.